Well, would you like to respond to that? To the issue of the retroactivity?
Absolutely. So 2 things to point out. On the retroactive part and the courts having the documents, that's simply not true. We have to remember this is a 2-step process. The first is the motion to vacate the judgment, to which we need to be able to show that the process serving occurred correctly. And so there we're talking about the documents of the process servers. Then after the judgment has been set aside, it's been vacated, you then go to trial to discuss the validity of the count. So that's where we're talking about the documents that go to proving the debt is owed. So in the first case, the process serving documents, the courts will have 1 page that shows proof of service, but it doesn't have the pictures, the GPS, the extra color. When we're talking about the second step, which is at trial, proving the validity of the debt, the burden switches back to the debt buyer, and now we have to remember that to put an other instance case and open up all the past obtained judgments, we're going as far back past 2010. We're going back into the past and asking for documents that really will not be available, because at the time our retention policy said we only needed 5 years after judgment or 2 years after. I don't know what the retention policies of the past were, but to make law today that now opens up our and takes away our ability to defend ourselves because of retention policies of the past simply can't happen. And I'd like to also point out, we've talked about Senate Bill 233, which was Senator Leno's bill of the past, having a 2014 and non-application. That was actually an agreement to make it prospective because of this very document retention policy issue and the fact that we do need to make language like this prospective.
Thank you.
And then my last question, Mr. Chairman, if you will.
Yes.
And as to the $325,000, I would need to know more than that. 325,000 judgments out there, but how many of those have people tried to go into a court and set them aside and have been barred by existing law? That would be the better judge of whether or not the existing law is working or not. In my experience, it's working. But the other issue is this language that you recently added in about, or any other instance. That kind of opens it up to a lot of different types of things where people would be coming in and they would not have the 6-year statute of limitation. They'd have no statute of limitation. Any other instance, they'd be able to come back in and say, hey, the judgment's no good.
Perhaps you weren't here in my opening comment. These are committee amendments trying to narrow the focus. This suggestion that this is a freeway where all these improper debtors are going to drive through to set aside these meaningful judgments is the debt buyer's characterization.
But aren't you saying there is a highway? Aren't you saying there is a highway, Senator? Because you're saying there's all these people out there who'd like to get it set aside, but they can't because of existing law.
I'm saying that this is your committee's amendments that I'm accepting to further narrow as author's amendments. Clearly our intent is on the misidentification. That's my intent.
Yeah. Well, my only thought would just be that I think that language should be more narrowed, because when we use words like any other instance, that opens a door to a lot of other things. But I'll leave it to the committee to discuss.
And that specifically is language that we're working with. Our intent was not to frustrate the amendments that came out of the Banking Committee, so we're in fact working with Banking Committee to make sure that we have the right language around that because of that. And on the retroactivity, I mean, this is an access to justice issue. If one of your proponents would like to address that issue.
Please.
Yeah, I mean, one thing that's hasn't been made clear is that the courts do retain every single document. That as long as a judgment is good, they have to hold on to the documents. Second, I've never seen a picture in a process server's taken a picture of someone who's been served. That doesn't happen. And third, they do, even in the initial, before the judgment's set aside, they have to introduce a responsive pleading showing that they have a meritorious defense. So it's not just that I wasn't served, it's also that I have a defense to this action. And when we're talking about retroactivity and you're talking about garnishing someone who never owed the debt, or any other instance, a person who already paid the debt or settled the case with a different debt buyer, when you're balancing that against whether the debt buyer retain documents that they never even used to get their judgment in the first place, I think it falls in favor of providing access to justice for the tenant. And again, all we're asking is for them to get their day in court. We're not asking for the judgment to automatically be set aside, but they get an opportunity to let a judge make the determination.
Thank you. Mr. Alejo.
Yeah, I often don't agree with my colleague, Senator Gallagher. We went to the same law school, but we're on different sides of the political spectrum on many things. But on this case, even before he spoke, I had the same two concerns, and wanted to see if those were addressed, because they're the ones that I'm working through in my own analysis. And certainly, I know people say they don't like the retroactivity, but the language of the bill itself, it goes back to a judgment entered on or after January 1st, and there is like this real concern about retention of evidence. And I used to work as a staff attorney for the court, and usually what you have is just a simple proof of personal service, and it just is the address, the date, the name of the person who served them, and that's about it. But when there's a question of whether somebody was served, the court goes beyond that. They have to call back witnesses, the person who served that, and so there's a real issue of retention and being able to give a fair process to a new policy that we're considering implementing here, and making it fair to all the people who are addressing these concerns. And there seems to be a sense that, well, if it's prospective and it's a reasonable date, then we could work with the new policy, the new rules. But going back to a 2010 date rather than something that's more reasonable, like a 2014, 2015 date, would I think allow a process to be fair to everyone involved, because it does go beyond just the simple proof of service. We have to bring additional evidence and witnesses that you have to, which would be the key issue in this type of a hearing, is whether the person was actually served or not. And then the last concern was on the amendments, and I know you worked with the banking committee, and it's only on this language, which I think it's incumbent that we have to have a tight language, narrowly tailored in regards to the case of identity theft and mistaken identity. And I would assume that there is these cases that do happen, but I'm sure there are a smaller percentage of the overall legitimate debts that people do not pay. So that's what we're trying to address. It's not the majority of the case. It's a narrowly a smaller percentage of the overall number of cases, but nonetheless, the way this language is written, it says, in the case of identity theft, mistaken identity, or other instance, it's that or other instance that, even as any lawyer would say, well, that's a broad loophole. What does that mean? There's no definition. It could be anything or other instance. And that's, I think, what our concerns are. How do you, with removal of those or other instance, I think would alleviate those concerns, would tighten it and narrowly tailor it to identity theft and mistaken identity, which you said was your intent. And I think that would make some of us much more comfortable if we're able to adjust that paragraph by removing or other instance. I don't know if you want to help alleviate my concern.
I would like, as my witness indicated, there's more that the alleged debtor needs to do. There has to be a responsive pleading that says, I do not owe this debt. I don't want anybody to lose track of the fact that, yes, I wasn't served, but yes, I do not owe this debt. This is the group of people that we're talking about. I do not owe this money, or I paid it, or I was discharged in bankruptcy, or the statute. I have a legal cause of action that I do not owe this debt. I will work with the chair on the language. We were up till midnight on Friday trying to get the language. We haven't got there yet, but I'm accepting the amendments as they are presented, and I'll say it's in the genre of misidentification is what we're looking for. Other instances, we're not trying to, hide do any fast one here. I'm not able to do that with this committee.
And again, Mr. Alejo, that's exactly the heart of what was raised as an expansion of what came out of the banking committee, and that's why we're working with the banking committee and the author to make sure that we're not doing that.
Well, those are my concerns, Mr. Wachowski, and I'm going to support the bill today, allow to try to fine tune and address these concerns as it moves forward. But today, I'll provide my support, but hoping that. Urging the author to try to address these two main concerns that I have.
Mr. Wagner?
Yeah, I wasn't going to get involved, but I've heard something that I just have to push back on. I almost always agree with my colleague, Mr. Gallagher, and I think he's right on this one as well. I can't tell you how many times, because I think it happens every time I try a case. When you're done, be it a default judgment or you've gone through a jury trial, the court says, do you want your documents back? Because we're going to destroy them. They don't retain them. They don't have to retain them. They go back to the lawyers almost all the time. And even, that's been my experience in 25 years. The courts will always, they won't let you leave the last day of trial without taking the documents. So it's not true that all the paperwork's with the court anyway. Even if it were, I don't know a single process that allows me to go get discovery from the court. I'm going to have to depend on the court to voluntarily turn this stuff up. I'm going to have to dig through their records. I'm going to have to try to ask them to do judicial notice of their own files, of a court file that may be 4 or 5 years old, maybe in a basement somewhere, may, frankly, in my experience, not exist. These are practical problems that just saying, oh, the courts keep them and we can just go through the courts and get the stuff. It just is just not the way it works that I see, and needs to be addressed as you continually try to amend this moving target.
Would you like my witness to comment, or is just
no? I'm going to ask.
Yeah.
I think we're done with the question. I'll ask you to close, and you can address that concern in your close.
We hoped in the language where the validity of the judgment is not challenged, the court may select the appropriate remedy. Other than setting aside the default and the default judgment, when the judge has all the information of the file in front of them, we're trying to respond to the debt collecting industry's concern that they have these good judgments, and that the judge should stop the collection of the garnishment, but allow the judgment to stand against the correct debtor. This is the practice in collections. Is that in order to get the judgment after you have a default, you haven't had your trial. It's not evidence that has gone in. You filed your complaint and nobody's respiled. There's a file there. So we hope that you can support this bill so that due process in California will be strengthened and people will be able to have their day in court if they believe that there's an unjust default judgment has been entered against them. And I urge your aye vote.
Thank you. I'm still looking for a motion. The motion is due pass as amended to appropriations. So moved. Thank you. Is there a second? Second. And a second? Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Aye. Alejo, aye. Chow? Aye. Chow, aye. Chu? Aye. Chu, aye. Gallagher?
Sorry, okay, I'll give it work.
Gallagher, no. Garcia? Weber?
Aye.
Weber, aye. Mainshine? Thurman?
Need one more vote?
Thank
so
you.
We'll put that bill on call.
Until we meet again.
Thank you. And it looks like that brings us to Senator Pan. Dr. Pan, we'll move to item number 5, SB 145. Good morning.
Good morning. Thank you. I think we're still morning, right? All right. Thank you, Mr. Chair, members. I present to you SB Senate Bill 145, which further clarifies that a hospital is prohibited from transporting a patient who's deemed medically unstable due to severe intoxication to another location, except when the patient is stabilized or appropriately transferred to another licensed health facility. There's been substantial evidence that reveals that Prime Healthcare Services are transferring patients who are admitted to the emergency room for acute alcohol poisoning to police departments, correction facilities, and county jails by calling 911. And despite being one of the largest hospital chains in the state, Prime has an unusually high number of cases where police are called on patients in the ER. For example, in the first 3 months of 2014, 124 emergency calls came from Shasta Regional Medical Center, which is a Prime hospital. This averages to about 41 calls a month. In comparison, Dignity Health's hospital, Mercy Medical Center, which is only located 2 miles away from Shasta Medical Center, had only 53 emergency calls in the first 9 months of 2014. What has been documented at Prime Hospitals highlights a hole in the current law when it comes to preventing hospitals from dangerously transferring patients. SB 145 is intended to stop and prevent this practice that poses a risk to patient safety. I respectfully ask for an aye vote, and I have witness in support.
Thank you. Your witness in support, please.
Good morning, Mr. Chair and members. Pat Whalen, Ellis & Wilson Advocacy here on behalf of United Nurses Association of California and Union of Healthcare Professionals, UNAC, a proud member of AFSCME. The opponents will tell you this bill is duplicative or unnecessary. And like anything, there is but a grain of truth in that. It is true that the federal EMTALA law has been on the books for 30 years that would prohibit this activity. It's also true that 43 states, including California, have enacted laws to mirror and augment EMTALA. But that doesn't answer the following question. Why is it that the American Medical Association found in a published Journal of Ethics that there were 527 hospitals that violated EMTALA across 46 states? Why did they find that of those 527 hospitals, 117 had violated the EMTALA Act multiple times? And most importantly, why did they find that for-profit hospitals were, quote, significantly more likely, end quote, to violate this law than others? SB 145 removes any ambiguity whether hospitals are intentionally turning away low-income patients or are mistakenly misinterpreting the law. SB 145 will remove the ambiguity.
Thank you. Anyone else in support?
Michael Young, California Labor Federation, also here in support.
Thank you. Anyone else? Opposition?
Good morning, Mr. Chair and members. Connie Delgado with the California Hospital Association here in opposition. As the Senator mentioned, this bill is about patient transfers, and I would like to note that the physicians are the ones that make the decision to transfer a patient. It is not the hospital that signs the document. That's a clinical decision that's made. And yes, this bill is unnecessary, as the provisions in this bill are already against the law of both state and federal. CDPH has total authority to come in and, if they see instances that were mentioned, they can certainly come in under current law and fine hospitals. And for these reasons, we are opposed to this bill.
Thank you. Any other opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner?
Well, I guess my question of the hospital, so if this is already against the law, what's the problem?
It's unnecessary. Hospitals abide by the law, and this bill is not needed.
Any other questions, comments?
Mr. Wagner's, the question was, you said it's not needed, and he asked you a question. I don't know if we got the answer. The question was, why is it then do we have so many instances of this occurring if the hospitals are abiding by the law? Are the doctors not abiding by the law? Is that and the hospitals are going along with it? I mean, what's the answer?
We've actually asked for the documentation that has been alleged against hospitals, and particularly one hospital in this scenario, and we have yet to receive any data that states the number of 911 calls that they can actually trace that those calls were made from within the hospital. So actually, we're not exactly sure that there is a problem that exists even with this facility that in question.
No other comments or questions? Senator, you may close.
Well, I would just note that that there is data showing that there's a much higher frequency of the use of 911. Now, we don't know who made the call from the institution and exactly what the internal aspects are, because that wasn't available. But certainly the 911 call logs were available, and excessive calls were made from the emergency room. So that's the concern, and so I respectfully ask for an aye vote. Thank you.
Thank you. I'm still looking for a motion, and the motion is due pass 2 appropriations. We do have a motion and a second. Call the roll.
Stone?
Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo? Chow?
Aye.
Chow, aye. Chu? Aye. Chu, aye. Gallagher?
No.
Gallagher, no. Garcia? Weber?
Aye.
Weber, I. Mainshine. Thurman.
That bill needs 2 more, so we'll put it on call.